So for more on Trump's growing legal issues, we are joined by criminal defense attorney Brian Claypool. Brian, great to have you on the program today. Always good to see you. Of course, you have to have a crime. You're a criminal defense attorney. You know that better than anybody. And while many believe Donald Trump could certainly be guilty of insurrection, he hasn't been charged or convicted. You heard Professor Turley in Alexandria Hoff's report say this is anti-democratic, in his opinion. So do you think this will stand before the Supreme Court?
Yeah, hey, Nita, great to see you again, and Happy New Year.
You too.
Yeah, so look, the decision by Shenna Bellows in Maine has a loud bark, but very little bite. I think it's more symbolic than anything else, because once the U.S. Supreme Court gets this, and they will probably before the end of January, because ballots have to be sent out in Maine, in Colorado by the end of January. But the Supreme Court is going to look at a couple issues, and you named one of them. Due process rights. Former President Trump was not even charged by the DOJ for inciting an insurrection. The DOJ investigated that. They didn't find enough evidence. So how can you remove him for a ballot for inciting an insurrection when our own Justice Department didn't find that? And then the second reason why, too, is there was never any trial. It's a due process argument. There was never a courtroom where former President Trump would have lawyers to put on evidence that he did not incite an insurrection. This is a unilateral decision by a Colorado Supreme Court and then a Secretary of State. And by the way, both of them are not jurors. They are not supposed to be deciding facts. Appellate courts are supposed to decide the law. So I see the Supreme Court intervening quickly, and I do believe with Jonathan Turley that they're going to reject this argument.
Well, with regard to the Secretary of State in Maine, pictures are emerging of her at two separate White House events. There are selfies out there of her with the president, suggesting political support of President Biden. And this is what she said about her decision to take the former president off the ballot. Let's listen.
So my job, I qualify Mr. Trump for the ballot, and under Maine law, any registered voter can bring a challenge to that qualification. In this case, there were 3 challenges, and I was required by law to hold a hearing, and I'm required to issue a decision. That's my obligation under the oath I swore to the Constitution.
Okay, so she said this was her requirement according to the oath that she swore to the Constitution. But, you know, there are Democrats in her own state that disagree with her decision. I want to read to you something that the Democratic Congressman Jared Golden said. He said, quote, I voted to impeach Donald Trump for his role in the January 6th insurrection. I do not believe he should be reelected as president of the United States. However, we are a nation of laws. Therefore, until he is actually found guilty of the crime of insurrection, he should be allowed on the ballot. And other Democrats across the country, including the governor of this state, Gavin Newsom, pretty much said the same thing. He said, if we're going to defeat Donald Trump, we need to do it at the ballot box. Well, what do you think about this?
Yeah, she was not required by law, Anita. Let's make that clear. She made a decision to interpret the Maine Constitution on her own. And that's the fundamental flaw in all of this. Ms. Weber, the Secretary of State of California, was spot on. What she said is, look, this is a 14th Amendment argument. Who should be deciding this? Not a Secretary of State in Maine, not a Secretary of State in California. This is a complex legal issue that should be decided by the U.S. Supreme Court. And Bellows is stepping out of bounds. Let the U.S. Supreme Court interpret the 14th Amendment, and let's not gut a fundamental right of U.S. voters to vote for who they want to in this primary and the general election.
So the Trump team is expected to file that appeal to the Supreme Court on Tuesday. Quick answer here. Do you expect the Supreme Court to make a decision based on party lines, a 6-3 decision, or do you think it will be a unanimous decision? What do you think?
Yeah, that's a great question. I think minimally at 6-3, I would not be surprised if this is along party lines for the reason that we said, that this is a constitutional violation. And by the way, Anita, let's say the U.S. Supreme Court doesn't rule quickly on this. It would be a violation of the law for Maine and Colorado to be sending out ballots without former President Trump's name on those. Because the law is, until the appellate courts have heard this, that the decision by Bellows, the decision by the Colorado Supreme Court is not binding until the U.S. Supreme Court hears this.
Right. Okay, good insight there. Always great to get your legal insights. Brian Claypool, and have a Happy New Year.
Same to you, Anita. Happy New Year.
Okay, thank you.